everyone. Welcome back to our Good Grief channel. I'm Veronica, the founder of Good Grief. And today I'm joined by Nik Sallie, an estate planning attorney and the founder of Tastemakers Legal, a boutique firm here in Austin that practices concierge level estate planning for families. Many of us assume that naming godparents or mentioning guardians in a will is enough to protect our kids, but there are real gaps in that approach that can leave important decisions up to the courts. Nik is here to walk us through what actually happens in those moments and the simple steps you can take to make sure that the people you trust can step in seamlessly if something unexpected were to happen. Nik, thank you so much for being here.
Thank you, Veronica. Hello, everyone. Thank you for being here. I'm Nik Sallie. I will start to present the PowerPoint in just a moment, and I'll just ask you to either give me a thumbs up or just to type in the chat that you can see it. So I am sharing the screen now, and this should be full screen. Awesome. Thank you for the thumbs up. All right, so today we will be talking about the kids protection plan, but I guess more broadly, the family wealth and protection and planning. And as Veronica said, I do have firsthand knowledge of what it means to lose a family member. And it is not only devastating, but it's something that you have to then navigate long after they're gone. And so, very briefly, I will just share a little bit more about my personal story so that you can understand where I'm coming from and why Tastemakers Legal practices concierge level estate planning to protect families. I have had experiences with traditional estate planning multiple times. And traditional estate planning is where an attorney will just deliver documents to you, your will, your trust, your medical power of attorney, things like that. And then you just put them in a drawer. They gather dust. You forget that they're there. And then when you pass, your family is left with the documents that probably don't actually work because they haven't been updated in 10, 15, 20 years. I've had a similar thing happen to me where with my mother, we had her sign up for a will through my former employer. It was more of a prepaid legal plan, and they were offering wills for really, really, really cheap, like $300 or something like that. I offered it to my father. He declined. My mother said she wanted to do it. We had the will drafted up by the law firm that was chosen. And then as I got the documents back, I just so happened to look at them because I'm a trademark attorney by trade. And at that time, those years ago, I wasn't yet in estate planning, but I found typos. And so I called the law firm and asked them, or I emailed them and asked, what's the implication of these typos? Are they going to, be okay? Will the documents work when we need them to work? And I got crickets, no response. It was very difficult to reach anyone. And that's because in traditional estate planning, they just hand you the documents and disappear. I finally did get an answer from the law firm, but it was just more of a flippant, like, no big deal. It's okay. There wasn't really an explanation. There wasn't a follow-up or customer service to try to help my mom or help her understand anything. So it was very low quality. Then with my aunt and uncle, I actually paid to have their estate plans done when I was in college. And it was because I'd heard so much about how important estate planning was. And um, they didn't have a lot of assets, to be honest with you, just maybe a small house, but really nothing else. And I just wanted them to be okay. Well, when my aunt passed, all of her property went to my uncle. At that point in time, I had already moved to Austin. I was no longer in Dallas, Fort Worth, and my uncle became sick. His sons were taking care of him there, but I was kind of tasked with kind of the looking after him for some of the things. And then he passed, but no one told me. And so at that point in time, I didn't understand how to help move the estate along or how to do probate. And when I reached out to the attorney who had drafted the wills for them, she had died. And so because she had passed away, I didn't know of any succession planning that she had done. I didn't know what attorney had taken over the files for her, that kind of thing. And it was just really difficult to get through the process because there wasn't anything in place to hand off my aunt and uncle's plans to another attorney to help us. And then finally, this past summer, I was at lunch with a colleague who is the founder, CEO of a tech company here in Austin. And I got a call from my sister in Dallas, and she let me know our father had passed. And it was sudden. He had just gone in for a routine medical procedure that wasn't very complex. And unfortunately, though, there were complications after he left the hospital and he passed away. He had told my brother that there's supposed to be a will. He did not tell anything about the will to my sister and myself. And so now I'm here in Austin while they're in Dallas. And at this point in time, no will has been located, and my father passed last August. So as you can see, it becomes very, very difficult when there are gaps in the type of care that people are using in estate planning. When there's no succession planning, when there's no follow-up that is regularly happening to make sure that the plans are in place and up to date, or if the families are not talking to each other and their beneficiaries to tell them where the will is located. So those are some cautionary tales that I just want to start with to let you know that firsthand, my heart goes out to all my clients. And that is the reason why I practice concierge level estate planning, where we will be with you and your family through everything. And we will be checking with you on a regular basis to make sure that your plans are updated and that they grow with you and change with you as your life changes. So, with that, let's dive in. Who will care for your children? When I was previously married, this is something that I did not really think about, even though I knew about estate planning when I was working at Facebook/Meta. My then husband and I were pretty good about financial things, but you don't know what you don't know, right? And so, on a practical level, what would happen to your children if something happened to you tonight? Um, it's really something we don't think about because we're busy and we're going through our day to day. I know for me and my ex-husband at the time, whenever we would leave to go to dinner, we would just simply leave a phone number, our cell phone number with the babysitter. But we hadn't really thought through what happens if we don't come home. The babysitter doesn't have anyone else's numbers but ours. And so that's a gap in communication that existed then. And so we want you to start thinking about short-term care for your kids, short-term guardians as well as long-term guardians. So, on a practical level, let's think about short term. As I just mentioned, a lot of us go out. We go out to dinner, we go to the movies, or we're at a conference or whatever it is for work. When we're not home and we're leaving our kids with the babysitter, um, have we thought about who lives closest to us that could get to our children fast if something happened to us? And this is in the case of incapacity or death. So if you're in a car wreck and you end up going to the hospital, even though you're fine, now you're not able to leave and you can't go home. Who's going to go get your kids? There are some people who think about their godparents and other people who they love dearly, who their children love dearly, but those godparents live in a different state because they were best friends in college, and now, maybe they went to college in California and now they've moved to Texas. Well, their best friends still live in California. That's not going to make a great short-term guardian for your minor children. So what would happen is the police would be called by the babysitter because there's no one else they could reach. And at that point in time, the children would have to be taken into Child Protective Services because the police have no other guardian to designate. They can't make that choice for you. So those are some pro tips for the short-term guardian. Let's talk about long-term guardian. So if you were to pass away, who would you want to raise your children? Who in your life shares the same values that you share around your belief system, how finances should be handled, the type of education you want your children to actually have? Um, do you want them to be able to travel? Do you want them to have educational experiences outside of the US? Who are those people in your life who maintain the same values that you do and that you would trust with handling the welfare of your children? Now, sometimes the short-term guardian is the same as the long-term guardian. But if not, another consideration that you want to think about is if you're thinking of a couple that would raise your kids, are you okay with both of those individuals taking care of your children? What you might find is one of the individuals shares your values, but the other doesn't. So if the person whose values you do share happen to pass away and the other spouse is the one that's going to be the one to continue raising your children, are you okay? Are you feeling confident that that person could do a good job in raising your children? So those are some things to think about. All right, we've talked about short-term guardians. We've talked about long-term guardians, and I've given you considerations for each. You want your short-term guardians to be the people who live closest to you, like within 10 minutes from your house, that can get to your kids quickly if something happens to you. Long-term guardians, you want them to be people who actually share your values around how you would raise your kids across those different dynamics we just talked about. Now, when we talk about receiving assets, obviously minors cannot receive assets directly. I still consider 18-year-olds to be minors, but obviously the law considers them to be adults. That's a different story. We'll talk about that in a moment. But I want to just kind of go through a few high-level things around the assets and what your estate looks like. So, at a high level, when we're talking about your estate plan, there's a couple of different things you need to know. One is the scenario of if you have no estate plan, how is your estate going to be handled? How will your assets be handled if you don't have a formal plan in place? Meaning you don't have a will, you don't have a trust, and maybe you haven't even done your ancillaries. The ancillaries are the extra documents that come along with the will, such as your medical power of attorney, your financial power of attorney, which the medical power of attorney is the document that gives other people permission to make medical decisions for you, like what kind of medication, what kind of surgery you would be able to receive if you're incapacitated. The financial power of attorney gives them permission to take care of your finances, such as paying your mortgage, getting access to your bank accounts to pay for other things, selling real estate if you needed that to have happen for you, that kind of thing. So if you don't have any of those documents in place, a will, the ancillaries, a trust, then the state of Texas has a default plan for you, and it's called when you die intestate. Dying intestate means you had no plan. The next big category is when you do have a plan, and that plan only includes a will, and that's what you're seeing on the screen here. Your default plan, when you have a will, is probate. And this is basically the process you go through where your will is sent to the court and the judge has to review your will and then sign off on it to make sure that your estate is distributed the way that you wanted it to. Now, here's the thing. Texas is supposed to be a probate friendly state, meaning their probate process is supposed to be a little bit faster than other states. But comparing us to other states really isn't helpful because in California, it could take, I don't know, 12 to 16 months, but just in Texas alone, it could still take 8 to 12 months. Imagine that your loved one has passed away and you have to wait a year before you can get access to their bank accounts to pay their mortgage, their other bills and things that they had. That is a long time to hold up their estate, but also to hold up your life because you are the person that's next in line to help take care of these things. Another thing you want to know about probate, in addition to how long it can take, which we don't know until the judge actually starts on the case, it's very costly. When you go through probate, you have attorney's fees that you have to pay to have the attorney bring the case before the court. You have executor's fees. There's also things like appraiser's fees because you'll probably want to get the house appraised or things like that. There's court filing fees and bonds. And then on top of that, because probate is public record, you have creditors' claims. So any company that the person who passed away owes will now know that they passed and they will come calling to get paid. So when we look at probate and the person's will going through probate, you have issues around the timing. How long is it going to take? We don't know. You have issues around the cost, and you have issues around privacy concerns because it's a public record. So you want to keep those things in mind. Now, I we could be dating ourselves here, but for those of you who remember Anna Nicole Smith, back in the day, the actress, there was an issue where um, she died unexpectedly. And what was really interesting about that is even though she was a celebrity, and we tend to think that celebrities are really private people, her will is public record. It's right here on the screen in front of you, the actual document. And so, when you want to keep things private, unfortunately, a will is not the way to do it. Yes, you have the documents in a binder. Yes, they're on a shelf in your house, but once they go to the court, anybody can read them. So, here's something I want to pause and talk about briefly when it comes to children and them receiving assets at the age of 18. You just heard me talk about the fact that probate is a public process. Well, if this particular estate has monies that would be paid out to the child as a beneficiary, and the child has reached the age of 18, they are considered an adult in the eyes of the law. That money can be transferred to them. But just because it can be transferred to them does not mean that they have the knowledge or the maturity to manage it well. And so if you are 18 years old and you suddenly get a payout of $200,000, $500,000 from an estate, do you think that you are going to be savvy enough to invest that money, save that money, spend that money in a way that actually adds to your lifestyle? Or would that 18-year-old possibly make some bad decisions and maybe go on a spending spree? That's something that we have to really be concerned about because it's not just the child that's at risk. It is the fact that because it's a public record, other people will be now contacting that 18-year-old to basically scam them out of that money. And so a will is not always enough. The other thing I wanted to say actually before we get to this next slide is one of the other considerations that a lot of parents aren't thinking about for their children who are maybe 16 years old or 17 years old and they're about to graduate high school and go into college. We as parents, because I have a 12-year-old daughter, we are so used to being the people who are financially, emotionally, spiritually, and also physically taking care of children, meaning we are the first nurses or doctors, before we actually take them to the doctor. But once they turn 18, all of that is legally cut off. So if your kid goes to college and they get into an accident, such as if they're a college or a student athlete or something, and they get hurt in their sport, when they go to the hospital, the doctors and nurses are not legally obligated to speak to you because now your child is considered an adult. And if your child does not have their own medical power of attorney that grants you access to their medical documents, then the doctors and nurses do not have to update you about their condition. And at that point in time, going to court to try to get conservatorship or guardianship and force them to do so it's very taxing emotionally and financially. And so having documents in place to where your children who are now considered adults at 18 have their own ancillaries, they have a financial power of attorney that grants you access to their bank accounts and things like that. Those are some things you need to really think about if you have students, kids who are about to go off to college. All right, so let's talk a little bit about the numbers here. So since we talked about the short-term guardian and long-term guardian, we've talked about the default plans that the state of Texas would have for you. One, if you don't have a will at all, if you die intestate, the default plan that the state might have for you. But if you die with the will in place, you're still going to have to go through probate, loss of time, loss of privacy, loss of money. But let's see how much that could actually add up to. So nationally speaking, in general, probate costs could be anywhere from 2 to 5% of your estate. So on the screen, you see just some examples of some things that could be in someone's estate. There's a family home listed here for 300,000. There's a rental property. We actually have some stocks, bonds, and bank accounts on here for 380,000. Business interest if you do own a business. We could include life insurance policies here. I do find sometimes with my clients, their life insurance policies are one of the larger portions of their estate. And you can see that we have like the life insurance payout to a minor could be 1 million. And that's what you're seeing. Those life insurance policies could be really up there depending on how many you have. Um, Now, we live in Austin. Um, as I look for homes now, I am not seeing that many that are $300,000 in the areas that we're in, and I'm in North Austin. So we could even bump that up to like 500,000 probably in this area or more, just because continues to grow. So I'd love to find something for 300,000, but that's just not going to happen. But when you look at this example of an estate on the screen here, the total is just over 2 million. So if you took 5% of that, what you stand to lose going through probate is $100,000 that could have stayed with your family. $100,000 that could have stayed with your children or their caretakers to take care of them. $100,000 that could have gone to a lot of different things for their education, their health, their maintenance, all of that. But instead, it goes to their attorneys, probably the same attorney who actually drafted your will. So they're double dipping there. It goes to the court, it goes to all these other things. And this doesn't even count how, many creditors might be knocking at the door. So you can very easily lose 6 figures of your estate by just having a will. Okay, so let's talk about the foolproof way to avoid probate. If you don't want to lose 6 figures of your estate and you want to keep everything private, then there are ways to do that. The ways to do that is a revocable living trust. And at the top of the screen, you're going to see it says a fully funded living trust. And the reason we're saying fully funded is because once you actually create a trust, if you don't move your property into it, it's no good because it has nothing in it to protect. It's just sitting there empty. So you want to actually fund your trust. So as we look through this, you can see there are like 6 different things that you can look at here. So retitling your investment accounts. When you go to the bank, you can move your bank accounts into the trust. If you have a home, you would want to basically take the deed and retitle the deed into the name of the trust. All these things that you see here, you would want to put into your trust so that the trust owns it and then you own the trust. So, probate is completely avoidable if you're using tools like this. So, if you have the trust, you have to fund it. And once it's funded, those particular assets are protected because when you pass away, there will be no probate. There doesn't need to be court involvement. Your family will now have your attorney handle the transfers in private in their office. And that way, there's this entire system of control that remains in place to make sure that your wishes are honored and that everyone who's supposed to get whatever asset you wanted actually gets that. So, let's talk very briefly about estate tax. We won't spend too much time on this because obviously I would want you to talk to your CPA or a financial advisor about this. But this is just an example of estate tax in addition to what would go out for a probate. So estate planning is also used to minimize your tax responsibilities when you can. But I will tell you that with the big beautiful bill, some rules have recently changed. In the past, it was something like 13.65 million. If that was what your estate was, then that would trigger some kind of tax event. Now, with the big beautiful bill, I believe that number has been raised to 15 million. So that's 30 million per couple. And so it's possible to have a tax event when you have that type of estate. If you don't have that type of estate, then you don't have to worry about this tax event. For most people, they don't have to worry about this tax event. But in the case that you do have assets that total the 30 million mark, then that's when you want to bring in your financial advisors, you want to bring in your CPAs to help you actually come up with a plan along with your estate planning attorney to see how to maximize your benefits and minimize your risk in that situation. So, will your assets be lost to the state? Um, this is something that I had not thought about for most of my adult life, but now that I've moved into asset protection, it is very interesting to know how much the state of Texas and every state around the US actually holds in unclaimed property. So, no matter what state you live in, you can Google unclaimed property state of Texas, and there will be a website that comes up and it will show you a database where you can type in your name or a family member's names, and it will bring up unclaimed property for you that possibly does belong to you. You could find old bank accounts in other places where you used to live. So I used to live in Dallas, Fort Worth. I've found bank accounts that I had 15 years ago. There's still money in them, and I didn't realize it. I thought I had closed everything out. There are other accounts that that website might hold that will show you hundreds, maybe thousands of dollars that are just sitting in there that you didn't claim because you didn't know it was there. And so um, the estimated total of these unclaimed property assets across the US is about $58 billion, billions with a B, that the states are holding, and they're just waiting for people to come and find it. But there's a lot of people who, one, they don't know that that unclaimed property exists. Two, they don't know about the website. And three, they've never gone to actually use it. So I want you to think about your situation now. Do you think there's possibly some old bank accounts or assets that are sitting out there that you don't know about that you want to claim? Those websites are a great place to start. So, moving on. We've talked about probate, we've talked about wills, and now we've talked about trust being a shield for you to put all of your assets in so that you can avoid probate and loss of really valuable assets and other things like that, and also avoid creditors being able to take those funds. So really, you want to make your living trust the actual treasure chest for your family. So, Tastemakers Legal is part of Personal Family Lawyers, PFLs. It's a network of over 600 attorneys in the US who practice this concierge level of estate planning. And when you're choosing a trust, that is the way to make your assets airtight so that you can give them to your children, making sure that it passes on to your children's children. Um, And also for those of you, some of us we have different family dynamics, and I want to acknowledge that. Some of us aren't as close to our family as we are with our chosen family, who are like our best friends. If you want to leave something to your best friends or their kids in your plan, in your trust, you can also provide for them. And for those people who might have a family dynamic where there's really someone who maybe is unsafe, or you don't really feel compelled to leave them something, you can be very explicit in your own planning that you are not providing for that specific person if that's what needs to happen, and that's what will keep your family safe. You have complete control when you're drafting your will, and you have complete control when you're drafting your trust, because we will design those documents according to your wishes. Very briefly, years and years ago, there was a case with Terry Schiavo, and I'm sure most of us have heard that case from when we were younger. But she had an accident, and she ended up in the hospital incapacitated. And there were stories around the issues her husband had in the hospital around whether or not she could have hydration and other things like that. Um, a lot of the provisions in the ancillaries, like your medical power of attorney, your HIPAA release, HIPAA meaning this is the document that allows people to get your health information and get updates about your medical situation. She didn't have that in place. And the details in those papers, if she did have them in place, did not provide for whether or not nutrition and hydration would be provided for her. So it was a really, really tough story to hear. And so, again, that's why it's very important to work with a lawyer to design the plans that you want so that your wishes are honored, even when it comes to life support, even when it comes to things of that sort. So let's talk about the kids protection plan. There's some steps you can take, and basically, I want to just try to break this down and make it as easy for you as far as what you can do. So, when we're talking about the kids protection plan, this is a part of your estate planning that is just about your kids. It is about their medical power of attorney. It is about their financial well-being. It is also a document where you can put down what you want the guardians to actually do. You can leave information about their doctor, their dentist, what their health care should be, all those things. So you, again, choose the right long-term guardians. You want to legally document your choice. You want to choose short-term guardians that are close to you in proximity. Every choice you have needs to be documented. And you want to give instructions to the caregivers. I'm talking about how you want your kids to be raised, what schools they should go to, if it's private, if it's public. All of those choices can be documented and given to them. And then you want to basically make sure that these people are talking to each other. You want to make sure that they not only have the right documents, but that the short-term guardians have passed on information to the long-term guardians if that needs to happen. And you want to be talking to those people now in case these things change. So the people that we maybe wanted to raise our kids 10 years ago might not be the same people today. And you need to think about that and start having those conversations with them. Want to briefly walk you through our Kids Protection Plan website. This is the place where you can nominate guardians for your minor children in case something were to happen to you. And you can do all this for free, and it will create a document for you to print out and get notarized. And so I'm hoping that this walkthrough, this demo, will just shed some light on how you can use the website and how easy it is. But of course, if you have questions, you can always reach out to my office. When you get to the website, you should just go to sign up, and I've already done that. But when you click the dialog button, you can see that you will just put in your name, last name, and email and continue, and then it will log you in. So being that I already have a login, it looks pretty much the same. But you'll hit the continue button, and this will take you to the first page. I want you to notice at the top you have a menu that will show you how far along in the process you are. And so there are essentially 5 steps here. I recommend you watch the welcome video, which will give you some more information. But when you scroll down, it's going to ask you for your personal details first of all, and you just need to fill out your name, your address, and then your phone number, your marital status, and gender. And then the next section will be their kids protection details. So you will want to put in how many children you are including in this plan, the amount of money you're leaving behind. This could be the cash or something that's in your accounts, or the just what you can estimate your assets to be, and then whether or not you own your home, and then your email will go there. So really it's just all of your identifying information on this very first page, your personal details. The next page, when you hit continue, will take you to creating your short list. Again, there's an easy to follow video at the top that you'll want to start with in case you're more of a visual learner. And after you watch the video, you can scroll down and read the instructions here. This is where you want to list your individuals or couples that will be a guardian for your child. If you're listing a couple, you can click here and you can see that it will give you that dialogue there. You can put the first person's name at the top and the second person's name here. For an example, we just have an individual here, but even if you have an individual, I do recommend you go ahead and name a second and third person in case this person is not willing to serve as a guardian at the time that they are needed to, or in the case that they pass away before your children would be in need of a guardian. It's just great to have alternatives listed. So after you've listed 2 or 3 people, or maybe 2 or 3 couples, you want to click the continue button. You have your next video to rank your short list. And it just says, now that you've listed all the people you'd be willing to have raise your kids, you will want to put them in the order you want them to act from first to last. And so you will have 2 and 3 names here, and you can move the order up and down according to the buttons here. And so you may have a couple and 2 individuals. You can move the couple up to the top if you would prefer the couple be first in line to take care of your children. And then in this second column, you can rank the values in order of preference. So if it matters more to you what their relationship is with your kids than it does with the discipline style, then you'll want to make sure that you use the buttons to make sure that the relationship with your kids value is higher than the discipline style value. So these will all move up and down according to the order you'd like for them to have or to be in. The next thing is you want to add your witnesses. I recommend you have 2 witnesses here and that they be disinterested, meaning that they are not in your plan. They are not listed as anyone who would be taking care of your children. They are not related to you or the child is a best practice. And so it would be great to go ahead and list 2 witnesses. Typically in most states, they need to be someone who's over the age of 18, who's competent, and again, not named in the document. I do believe in the state of Texas, they have to be over the age of 14, but you will want to add the witnesses here. And so we have one test witness listed here. You would just click this button to add a second one and put their information in underneath. And then the final version here, the final page will be to preview your document. What you're seeing below is your legal nomination of guardian document and what it would look like if printed. If it does not look correct or there's a mistake or something you want to add, you just need to go back and press the back button down here and make any changes that you want. As you can see, we have the guardians named here. Your alternative guardians would be here, the second and third person, and then information here. Down here is where your witnesses will be. And as you can see, the first witnesses block is filled out. When you add a second person, they will be here. If you do not know who you want to serve as witnesses, you can leave it blank and just simply write their names in later on the document. Please remember not to sign these documents until you are with the notary. You must sign them in front of the notary. So once you hit continue, you'll click send me my legal documents, and then when you go to your email, it will look something like this: nomination of guardian information you requested. It will have some information at the top about my law firm and reaching out to me if you have any questions, and then it will have your document attached. It will first give you a sample document, and then as you scroll down, there is the document we just previewed. And so this is what you can print and take to a notary along with 2 witnesses, and the witnesses will watch you sign and the notary will watch you sign, and then the notary will also notarize for you. So I do hope that that helps. Again, should you have any questions, do not hesitate to reach out to me at Tastemakers Legal, and we will be happy to help you through any of this process. Or if you would like to talk through what a full estate plan will look like beyond just the guardian nominations, we would be happy to talk to you about that as well. All right, have a blessed day and take care.
Nik, thank you so much. That was such valuable information. I really appreciate you walking us through all of that. Now, I know we have your contact information here in case anyone would want to have a planning session with you or discuss what estate planning may look like for their families. I'll leave this here in case anyone's interested. And Nik, thank you for your time, and thank you all for tuning in.